My name is Paul Horvath. I am principal of the firm PH Solicitor specialising in employment law. Today I want to talk about unfair dismissals for small to medium business owners. Unfair dismissals may occur to you even with the best planning and treating employees as fairly as possible. That is because there is now a lot of information available on the internet about unfair dismissal law, including the Fair Work Ombudsman's website and the Fair Work Commission website. This can lead to a mistaken belief as to what is an unfair dismissal or what is bullying action by the employer. Also, as the cost of lodging an unfair dismissal is only around $70, the risk for an employee who lodges an unfair dismissal claim is very low. The Fair Work Act dictates that for a dismissal to be unfair, it must be harsh, unjust or unreasonable. This is hard to define and varies greatly based on the circumstances and the size of the employer's business. Small business employers cannot be sued for unfair dismissal until the employee has been with that business for at least 12 months. A small business employer is an employer with less than 15 employees. Then, the termination will be assessed against the Small Business Fair Dismissal Code. This sets out steps said to show a fair process in terminating an employee. For example, if he or she is underperforming, some warning must be given to them with an opportunity to improve their performance. Sometimes it would be fair for an employer to provide proper and appropriate training to the employee, including training courses. An employee of a business that is not a small business employer, so 15 or more employees, and has been employed for at least 6 months may bring an action for unfair dismissal if they argue that their termination was harsh, unjust or unreasonable. This can include as well, for example, where the person is terminated by way of redundancy and the employee argues the redundancy is not genuine and rather the employer wanted to dismiss them for other reasons. Note that the employee must have filed their unfair dismissal claim within 21 days of termination of their employment, otherwise the claim will generally not be accepted by the Fair Work Commission unless exceptional circumstances can be shown. The maximum an employee may claim by way of compensation in an unfair dismissal is 6 months' pay. This will include any notice pay and other payments made to the employee. In contrast, if an employee says he or she has been the subject of adverse action by the employer by bringing what's known as a general protections claim under the Fair Work Act, there is no maximum compensation they can claim. In reality, the majority of such adverse action claims settle at conciliation or mediation, and the average settlement is around $5,000 to $10,000. If you have been sued by an employee for unfair dismissal or a general protections claim, we have extensive experience in representing employers in these types of matters. We have won a number of these cases and reached very reasonable settlements in other cases. Please call Paul Horvath or Julia Eastoe on 9642 0435, that's a Melbourne number, so 03 for interstate, or email admin, ADMIN, at phsolicitor, phsolicitor.com.au to discuss your unfair dismissal case.